All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our cause number CV 17-48. We're calling it Paul E. versus Courtney F. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, but you need to keep track of that time for yourself. We've read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Good morning, Your Honors. My name is Paul Eckstein. I'm appearing on behalf of the appellant, Paul Elio. With me at counsel table is Todd Franks, who tried this case below. At the outset, I want to thank you for moving the oral argument to today. I was trying to figure out how I was going to fit 70 first-year law students in the room, but thank you for not having me do that. The trial court here committed 3 serious errors of law in addition to the error of law in awarding attorney's fees. I don't intend to talk about attorney's fees. We'll rest on our brief. I just make the point that the court based the award of attorney's fees on, quote, the unreasonable position taken by the father in opposing the appointments of Drs. Vigil and Aronsoft, and obviously, if the court does as we request to reverse those decisions, it's not only not unreasonable, but we're right on the law. The 3 errors of law that I want to talk about in this order are, number 1, the error of law that the trial court committed when it cloaked Diana Vigil and Diane Aronsoft with judicial immunity for their work as therapists. We're not talking about their work as experts. Secondly,
can a professional do both simultaneously?
There's
be
no
a therapist and an expert?
Can they do both?
Yeah.
Well, if one is providing therapy to a patient, in this case LE, one is providing therapy. One's not giving expert advice. One can't do both at the same time. In addition, there's no statutory or rule authorization giving the court the power to do it.
I think the court below relied on 25410A, Mr. Eckstein. Why didn't that give the judge below the authority to appoint Vigil and the other doctor to do what he appointed them to do?
410A.
I'm sorry,
yeah.
25410A.
Yes. Well, number 1, just in terms of authority, we're not talking about the constitutional issues, but just in terms of authority, the court must determine after a hearing that in the absence of a specific limitation, the parent designated as the sole fit parent, the child's physical health and would be endangered, and the emotional development would be significantly impaired. The court did not find that in its minute order of March 22, 2016, page A20 of the appellee's appendix, it said that there was a potential for harm if not managed correctly. There's, in addition to that being less than a secure finding, there's no finding at all and no suggestion that the father, as the fit parent and who had been making these decisions with respect to LE for 4 or 5 years, going back to the divorce decree, had done anything inappropriate, was not fit to make these decisions. So that, just in terms of looking at the statute, and without applying all the presumptions that the Troxel case requires, that statute does not apply.
As a matter of statutory law or any equitable principles you're aware of, does the court even have the power to appoint a therapist for a child?
The court has the power to order the parties to engage a therapist under 95A. And there's a question, Rule 95A, there's a question about where that authority comes from. But engage is a lot different than the court picking a particular person to serve as a therapist. And in this case, telling the father, you can't talk to your son if your son asks you a question about this.
But what if the parents or let's say we have a sole legal decision maker who is religiously opposed to this type of therapy? Does the court have the power?
It's not the case here.
No, I understand, but I'm just testing the limits. Does the court then have the power to say you shall engage in therapy?
Well, I think the rule gives the court the power to direct the father or the parent to hire a therapist, but that isn't what was done here. I think the rule, which doesn't have a statutory basis, but nevertheless the rule allows the court to do that. But the court said, this is the one you're going to use, and you can't use another. You can't consult another. You can't talk to your son about any of the issues that might come up. And this therapist, I instruct to talk with my expert from time to time and consult with the expert. And interestingly, what the court says is it's the therapist who determines the best interests, totally turning Troxel on its head, where deference is supposed to be given. And the two most recent cases from this court make that point clear. One as recent as November. The third error of law relates to the dual appointment, and I think we've talked about that. If I have time, I'll get to that particular issue. So let's talk about the cloak of immunity that the court purported to give the two, Vigil and Aronsoft, and let's be clear, they're both acting as therapists. It's clearer in the case of Vigil because there's a whole minute order that's devoted to that.
It's not clear in the case of Aronsoft, is it?
Yes, it is. Because if you look, first of all, look at the first minute order. Aronsoft is not yet appointed, but this is the minute order of February 26, which is page A8 of the appendix provided by the appellees. It says here, the court believes that a therapeutic intervention is necessary to guide the court and the parties through gender identification issues. And then it goes on to say, the court intends to appoint a gender expert. The court considers the gender expert to be a forensic one. That's okay, but it goes on to say, the court will expect the gender expert to provide input and make recommendations to Diana V. Hill and the parties regarding LE status, how to assess and interpret the information, and potentially how to proceed. That's the court's order with respect to the so-called expert. It's clear the court itself called these appointments hybrid appointments. They're dual appointments. There isn't any question about it. So the appellee tries to make the case that, well, this is immunity for expert services. We're not questioning that. What we're questioning is the cloak of immunity with respect to the services that the court has ordered these to provide.
Did your client consent to the appointment of a gender expert?
I'm sorry.
Did your client consent to the appointment of a gender expert?
No.
But your client has to pay for that expert
Yeah,
by
96%.
sua sponte ruling.
Absolutely, and not only has to pay for it, but there's no limit. We talk about that in our briefs. Ordinarily, when you appoint an expert, you would think that there would be some limit set. There's no time limit set, and there's no monetary limit that is set.
And to my reading of the record, there are no pending hearings. In other words, there's no review hearing. There's nothing more pending before the court.
It raises, the issue of...
Is that correct? Is my understanding correct?
Your understanding is correct. Okay. Your understanding is correct. Judicial immunity, just a final point on judicial immunity. The Griggs case makes clear it's a common law doctrine available to those performing judicial functions. The mother tries to make the case that, well, because they perform expert services, they're performing judicial functions. The Colorado case, which Hawaii v. Cotton, which relies in large part on Acevedo, an Arizona case, says no. You have to look at the functions, each of the functions. So it's clear that immunity cannot be given for therapeutic services. It's also clear under Arizona law, although we don't have a precise case, that under Article 18, Section 6 of the Arizona Constitution, the abrogation clause, that the right for LE to ever file a claim has been precluded and can't be precluded under Article 18, Section 6.
Would the anti-abrogation clause similarly apply to immunity afforded to special masters?
Does it a special master? No. I think a special master depends on the terms at which the special master is performing. But here, what we're complaining about is the services that have been ordered to be performed, medical services, healthcare services, whatever you want to call them. If this stands, any judge would be able to provide immunity to anyone that he or she orders to perform therapeutic services. If I could move on to the second point, it's so clear that what the trial judge did here was to strip the father's decision-making authority as the sole fit parent in violation of the 14th Amendment and in violation of Arizona statutory law.
Be clear, I don't think there's ever been a finding that mother's an unfit parent. I think there's been a decision that father is the sole legal decision maker and that he is a fit parent.
Well,
just to be clear,
if there isn't such, it said he's the sole fit parent. So
he's the sole decision maker for the child. Not. I agree with Judge Swan. I think fitness is more of a Title VIII juvenile court analysis rather than a Title 25 who has decision-making authority. Would you agree with that?
think I agree with it. I guess I'd hedge a little bit. But the point I want to make is
none of the 25403 factors that govern the determination of sole legal decision-making even go to fitness, right? I mean, decision-making can be joint, it can be sole, but the fitness is basically presumed in 25403. So I just hesitate to imply that because father has sole legal decision-making, mother is not a fit parent.
Well, it says he's the fit parent. The order says he's the fit parent.
I'm sure he's quite fit, but
Well,
that doesn't mean she isn't.
Okay, if the court doesn't exactly find that the mother's not a fit parent, look at A21 of the appellee's appendix and look at the minute order and what the court says. I could.
I'm interested in hearing it, and while you look for that, I would just point out that it would be anomalous to give an unfit parent 50-50 parenting time.
Mother has a history of discussing inappropriate things with L.E., such as, and goes on to talk. The court fully recognizes that mother has in the past plowed forward with an attempt to transition L.E., contrary to V-Hill's recommendations and contrary to L.E.'s best interest. Now, I suppose one could conjure up additional language in describing an unfit parent, but that's about as close to describing the mother as an unfit parent as I can imagine. So I know this court is familiar with Troxel. I know you're familiar with the Goodman and the Chapman cases. We supplemented the record yesterday with a case from Maine. And because I want to preserve some time with what the court said, it recognized Troxel, but clearly didn't want to apply it. And it turned all the principles in Goodman and Chapman, Chapman hadn't come down yet, on their head. When he said, candidly, he was going to micromanage L.E.'s care, despite these constitutional and statutory prohibitions. The trial court said, quote, I read your constitutional arguments, and I think it's an interesting issue in terms of how the court can go. This situation requires the court to micromanage. I understand the constitutional argument and the resistance to it, but I want to do it. With that, I will reserve the rest of my time. Thank you.
Thank you, counsel.
May it please the court, good morning. Catherine Sakimura, counsel for appellee Courtney F. Thank you. To begin with, on the attorney's fees issue, this court can affirm, of course, on any ground available in the statute, and there is significant evidence in the record that the parties have an extreme disparity of income, where the father, exclusive of bonuses and stock options, makes $250,000 per year, and the mother makes $10,000. First, as to the issue of fundamental rights, as Your Honor pointed out, Judge Swan, there is absolutely no finding that the mother here is unfit. And all of the findings as to her behavior go to the question of the best interest determination, of which parent, having to choose sole custody, would be the better decision maker. Given the history of the case, the court determined that it was not possible for the parents to share legal decision-making anymore, and that it had to grant sole custody. And in fact, the under advisement ruling specifically found they were both capable parents, and that he was comfortable with the mother's ability to parent the children.
But you've not appealed the legal decision-making determination or any of these determinations.
That's correct, because the mother feels that the most important thing was for Ellie to receive this specialized mental health care, and that she doesn't feel she needs to control the process so long as there is this appropriate and needed care for the condition that she is concerned about.
And that's an understandable position, but is it your position today that the court should control the process, or that the sole legal decision maker should control the process?
Certainly, it's undisputed that the court could have granted legal decision-making solely for Ellie's mental health care to the mother and all other legal decision-making to the father. Mother requested.
I guess my question is a little different. If the court, as it did here, granted that decision-making to the father, and the father had already engaged a therapist before these proceedings began, is it your position that the court should inject itself into that therapy?
This is an aspect of how the court crafted this order. The court decided that it was not safe for the child for either party just to have sole decision-making, that both parties had their actions in response to Ellie's diagnosis had harmed the child, and that's in the UAR on page 10, that the responses had already caused Ellie emotional harm. And for that reason, it made findings under 410 that it was necessary for the physical safety or physical health and emotional development of the child to issue this restriction, so that it was not a decision that the father should have sole custody and a later decision to put in an implementation or restriction on that custody, but it was a decision that was the only way that sole custody could serve the child.
I'm struggling to see how 410 applies here. First of all, 410, to my reading, has only been applied in one other published decision in Arizona history. And secondly, I don't see that the procedural prerequisites for 410 were satisfied, or, as Mr. Eckstein pointed out, that the substantive finding required under 410 was made.
So 410 does seem to be likely to be aimed primarily at a motion brought by another parent after sole custody has been determined into one parent.
Well, not primarily. I mean, it actually requires that.
Right. There was not a technical motion, but the mother did make this specific request for every aspect of this appointment of both of these experts in her pleadings.
So it's been your position all along, I just want to understand the record, it's been your position all along that the court should micromanage this therapy. Is that correct?
It was perhaps an unfortunate use of terminology by the trial court.
Well, let's take out the word micro.
But yes, that this is a situation with a child who is particularly vulnerable due to a medical diagnosis that is quite rare, and that both the parties' actions have not, and the parties' inability to communicate and work with each other to make decisions have not served this child.
Counsel, going back to 25410A, in the language that Judge Swan brought up, what is the absence of a specific limitation of the parent designated as a sole legal decision-maker authority, father in this case? What specific limitation did the trial court find, or did it make a finding that invoked, in your opinion, the authority to use the statute to manage the case in which the trial court did?
So in the UAR on page 10, which is on page 19 of our appendix, the court finds that Ellie's gender dysphoria diagnosis and the parents' response to it has already caused Ellie emotional harm, and that the father's position that Ellie was in remission is at odds with the experts. The complexity of Ellie's situation, the dynamics of the parties' relationship, and the potential for harm if it is not managed correctly lead the court to a conclusion that the child's physical health would be endangered and emotional development impaired if the court does not establish some guidelines for the parents in addressing Ellie's situation.
The father's response to Ellie's situation or diagnosis, is that the specific limitation that invokes the authority, in your opinion, under 410A?
The father's response is the justification for a finding of harm, and the specific limitation is the requirement that Luca receive confidential treatment from the same therapist that the father has agreed to previously, that the child has seen since 2013, and that an expert in treating children with gender dysphoria be appointed to advise the parties, the therapist, and the court on Ellie's need for care. And it is not just that Father chose Diana V. Hill to CLE, but in fact, Father, in his proposed findings, specifically requested not only that she be appointed to continue to provide this care, but that she be appointed on a safe harbor basis. All of the provisions in the safe harbor order are very similar to a standard order that is issued in many cases, and would have been understood by counsel what that would mean to ask for a safe harbor appointment of Diana V. Hill.
How can a therapist ethically divulge information to the court and wear both hats?
It is a rule that, well, the ethical guidelines that the Father cites in his brief specifically states that therapists are only prohibited where that they are not able to play dual roles, where it could be reasonably expected to impair the psychologist's objectivity, competence, or effectiveness, and specifically contemplates that psychologists might be required by law to serve in more than one role in a judicial proceeding, and that they must at the outset clarify their role expectations and the extent of confidentiality thereafter as changes occur.
Well, that certainly sounds like the way ethical rules are drafted, but there's still this troublesome statute that has a privilege attached to this type of therapy. And there are no, I mean, the only exceptions are mandatory reports, I suppose, for abuse, but there are no exceptions for winking to create judicial immunity, are there?
Well, I think there's two questions here. First is the dual role, separate and apart from the immunity question, that this is the type of role that includes both therapy and a court expert role that is routinely appointed in cases where there's extreme high conflict or the child is particularly vulnerable.
But what's the statutory authority for a therapist just divulging everything to a judge? I don't see any authority for that. I can understand why you might argue that everything the judge did seems like a good idea in this case. What I don't understand is where the judge had any legal authority to do it.
Well, the judge did not require divulging of therapy, and in fact prohibited the therapist, the safe harbor therapist, Diana V. Hill, from releasing records to the parties or participating in the judicial decision-making process as to custody decisions so that the records would be confidential. And the limitation on her giving information to the court are solely as to mandated report or harm, and information about the process of therapy in terms of whether or not therapy is needed.
So there's really no difference. The only reason that Ms. V. Hill has immunity in this, or was given immunity in this case, is that the parties are in litigation. If the parties weren't in litigation and she were just providing the same services to the child as she is now, there would be no immunity, right?
Diana V. Hill is playing a different role here. If the parties had merely privately engaged her, she would be not providing confidential therapy to the child. The parents would have a right of access to see the records and to direct the treatment of the child. This appointment is part of the court's the extension of the court's power to oversee the post-judgment issues of whether the child is protected.
Okay, the extension of the court's power sounds like a giant postulate in this argument. Where does that power come from?
Well, the court does have the power to ensure the safety and well-being of children who are the subject of custody.
Where does it say that?
Certainly there is there's an equitable role, but I believe that in the Rule 95A power does contemplate that there would be an appointment of therapy that would continue past the judgment, and courts have continuing jurisdiction in custody cases, which of course...
Doesn't Rule 95A have to be grounded in a statutory, in some sort of statutory language?
Yes.
And if so, where's that statutory language found?
The continuing jurisdiction of the courts that have been recognized by this court in Reed versus Reed. Sorry, I'm trying to find the citation.
Continuing jurisdiction, it has nothing to do with substantive decision-making power. And I'm loath to say that the court can simply create its power by making a rule. I mean, that's a Pandora's box you really don't want to open, right? I mean, we could basically supplant the entire legislature that way. I don't think that's what the Constitution contemplates.
Certainly, there has been no challenge to the power under Rule 95A generally in this case as to whether or not it was properly enacted and whether or not it generally provides the court with the power to order that parties proceed to have mental health services for themselves or for their children. And as to the immunity issue, this role by Vigil and Dr. Ehrensaft is similar to the roles, some of the roles discussed by the Arizona Supreme Court in Acevedo. There, the court said that that probation officers would have absolute immunity for actions which are necessary to carry out and enforce the conditions of probation imposed by the court. So even after the sentencing has occurred, the order requiring them to enforce the conditions of probation, those actions will be subject to immunity. And so a post-decree order ordering therapists to provide care to a child that was confidential in nature for the protection of the child's safety would also fall under that same rule in being granted immunity.
So there's a statute that says that parents, including your client, who does not have legal decision-making authority, are nonetheless entitled to inspect the medical records of their children.
Yes.
And the court just swept that statute aside.
Well, there is an exception to that statute that provides that when the therapist finds that it reasonably could cause substantial harm to the patient, that the therapist can withhold those records to the healthcare decision maker.
Yeah, but I don't see an exception that says the court can just decide when you get your statutory rights and when you don't.
The court made a finding that exception applied. Certainly, the statute would require Diana Vigil to independently make that determination.
Right, and that didn't happen. And the court basically substituted itself for the therapist's judgment, which strikes me as also problematic.
In a way, it did happen because Diana Vigil herself made this request that the records be confidential for Luca's safety, and that the parties not have the ability to see and know everything that Ellie, discussed with her in the therapy, because that she felt that it was necessary for Ellie's protection. Thank you. Additionally, as to immunity as an initial matter, the question simply is also not ripe. Whether or not particular activities are subject to immunity depend on the context of the actions. And in fact, none of the cases discussing immunity that are cited by appellant involve an appeal from an order, but rather the act within the context of a tort action after the alleged tortious activity has occurred. And as to the anti-abrogation clause, of course, appellant concedes that judicial immunity is a common law doctrine, and the anti-abrogation clause does not restrict the court's ability to modify or delineate the common law causes of action. And because immunity is a policy decision that certain actions do not exist, the anti-abrogation clause is not implicated.
I just have to ask, I'm sorry. Why is judicial immunity in your client's interest? Why are you arguing this point?
The mother requested this judicial immunity because the father had sent a letter to Diana Vigil indicating that she did not have immunity for her actions, and that Diana Vigil had communicated to the mother that she felt that she was concerned about a retaliatory suit from the father, and Dr. Ehrensaft indicated that she would not be willing to take on an appointment in such a litigious case if she didn't have immunity. And so the policy goals of this are so that the best experts are available to the parties.
All of which raises the question whether the limits on the court's authority to force people to retain specific providers might have some wisdom behind them. Because if you find that providers are refusing to get involved in these court appointments, perhaps the private ability of a sole decision maker to simply make those decisions and engage in a private agreement with a provider who is willing to serve has some practical wisdom as in addition to its legal underpinnings.
A ruling that courts did not have the authority to appoint specific therapists for various roles would have broad implications. Courts use this power under 95A to appoint reunification therapists in cases of abuse, to appoint therapeutic supervision, which of course is also now under 95D, but that they appoint specific experts in situations where it would not be appropriate for a parent who has supervised visitation, for example, to choose that expert, nor perhaps would it be appropriate for the other parent to choose that expert.
A parent who has supervised visitation is quite unlikely to have legal decision-making authority. But is there any authority to suggest that the parent with legal decision-making authority has no say in the identification of an interventionist?
I think with a finding of harm that power is well contained within 25-410. And the combination of Rule 95A and that provision allow the court to make any order that it finds is necessary to protect the child from harm when granting sole decision-making to one parent. I think that power is particularly necessary in a situation like this where you don't have an unfit parent and a fit parent, and that's why there's sole decision-making. Sole legal decision-making here is solely because the parties cannot cooperate. But the parties have engaged in various behaviors that did not allow the court to find that this child would be safe if sole decision-making was granted only to one parent without any restrictions.
But again, the premise of your argument is that the court has some supervening authority to make the best parental decisions for a child merely because the parents are no longer married. The government steps in and makes these decisions. I don't see that embodied in law.
I think that is inherent in the power that the court has to make decisions about the best interests of children and to place restrictions under 403.
Well,
and
403, though, let's be clear, requires the court to determine the best interests of the child in the context of assigning legal decision-making and parenting time, both of which it did here. At that point, isn't the court's role over, or does the court continue to have a seat at the table?
Well, as to the restrictions, the specific orders about the therapy, those are aspects of that legal decision-making power. The court determined that in making the decision about who had legal decision-making, this was an aspect of the order that made it necessary both for it to be in the best interests of the child and to protect the child from harm. This is an aspect of that best interest decision-making where the parties have submitted themselves to the court because they are unable to agree with each other and have necessarily understood that would mean there's a possibility that the rights they have would be restricted based on what the other parent wants. Here, the mother requested these orders, and the court found that the child would be harmed if they were not issued as a restriction on the father's sole decision-making, and the state provides that the judge the statutory authority to do so under 25-410. Additionally, the statement that there are no pending hearings is incorrect. There may not have been any scheduled at the time of that order, but given that the parties have been in constant litigation since 2010 with or without a petition, it was reasonable for the judge to assume that they would be, and in fact there are pending matters right now with hearings set. Finally, as to the experts' roles, they are authorized to have these dual roles, not just ethically, but also there is nothing in the statute that says that 95 and 25-405 cannot work together in the appointment. And for those reasons, we request you affirm the order. Thank you.
Thank you, counsel. Mr. Eckstein?
I have a couple of points, and only a couple of points, and then if you have questions, I would be happy to respond to them. With respect to the mother's fitness, I acknowledge that the language used was that the father shall have sole decision-making power. But as I said when I was here in my opening, the court came as close as it could to determining the unfitness of the mother. At page 305 of the index of record, page 10, the court found that mother engaged in behavior that demonstrated, quote, her lack of foresight for the emotional safety of L.E. and engaged in actions that were, quote, destructive to L.E. and, quote, placed her personal agenda ahead of L.E.'s personal interests. If that isn't a finding of lack of fitness, it's as close as one can get to it. Secondly, Judge Swan asked, what if there was a religious objection? How would the court deal with it? And in fact, in Diana H. v. Rubin, a 2007 case from this court, the court held that a parent's religious objection to immunization takes precedence over the state's interest in making medical decisions for a dependent child. And in that, it used a strict scrutiny analysis. I know, Judge Swan, that you declined to do that in the Goodman case. And one doesn't have to use a strict scrutiny analysis in order for the father to prevail. But since we're talking about a fundamental personal right as set out in ARS 1601 and 602, and as recognized by the Supreme Court in Troxel, I ask you to think about it seriously, of using a strict scrutiny analysis. As I said, you don't have to use it for the father to prevail. But this is the time to do it, to signal to other judges that the analysis that is required is one that is typically used where a personal fundamental right is involved.
Do you think it's necessary in this case to reach the constitutional issues?
Well, it's not. I understand the imperative of resolving all the statutory issues and not getting to the constitutional issue unless you absolutely have to. But if you're doing a constitutional analysis here, as we think is important to do, then I think you have to do, you don't have to, but you should use the strict scrutiny analysis. Thank you.
Counsel, thank you for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.